Get ready for the dictation. Dictation will start in 5 seconds. Start. In many of these decisions, the expressions vested rights or accrued rights have been used while striking down the impugned provisions which had been given retrospective operation so as to have an adverse effect in the matter of promotion, seniority, substantive appointment, etc. of the employees. The said expressions have been used in the context of a right flowing under the relevant rule, which was sought to be altered with effect from an anterior date and thereby taking away the benefits available under the rule in force at that time. It has been held that such an amendment having retrospective operation which has the effect of taking away a benefit already available to the employee under the existing rule is arbitrary, discriminatory, and violative of the rights guaranteed under Articles 14 and 16 of the Constitution. We are unable to hold that these decisions are not in consonance with the decisions in Roshan Lal Tandon, B.S. Yadav, and Raman Lal Kesav Lal Soni in state of Bihar and others versus Mithilesh Kumar reported in 2010 SCC 467, the Honorable Supreme Court has observed as under both the learned single judge as also the division bench rightly held that the change in the norms of recruitment could be applied prospectively and could not affect those who had been selected for being recommended for appointment after following the norms as were in place at the time when the selection process was commenced. The respondent had been selected for recommendation to be appointed as assistant instructor in accordance with the existing norms. Before he could be appointed or even considered for appointment, the norms of recruitment were altered to the prejudice of the respondent. The question is whether those altered norms will apply to the respondent. The decisions which have been cited on behalf of the respondent have clearly explained the law with regard to the applicability of the rules which are amended or altered during the selection process. They all say in one voice that the norms or rules as existing on the date when the process of selection begins will control such selection, and any alteration to such norms would not affect the continuing process unless specifically the same were given retrospective effect. Now, adverting to the contention raised by the learned counsel appearing for the respondents, I am of the opinion that it is not open to the state of Jharkhand to contend that the notification dated 5/3/2010 of AICTE would be applicable in the case of petitioner also, as the said notification has been made applicable with retrospective effect. The state had adopted the above AICTE notification only on 31st 3rd 2012, and the name of the petitioner was duly recommended on 10/8/2011 and 7/9/2011. If the contention of the respondent state is accepted, it would result in invalidating several appointments already made, and thus it may bring in a chaotic situation. Stop.